So for this first lecture on Chapter 16, Civil Rights, we want to talk about the role of civil rights in the U.S. Constitution, with the main point being that at the very outset, equality was really not on the radar for the framers of the U.S. Constitution. And then even when it was introduced with the Civil War amendments, the 13th, 14th, and 15th Amendments, they were very quickly undermined by actions that were allowed to be taken by the court, but also during the Reconstruction era. And so what we want to do is just kind of give an overview of the challenges of protecting civil rights in the U.S. Constitution. So the first observation is that equality was just not that important to the framers of the U.S. Constitution. The word equality was never mentioned in the Constitution. It was never laid out in any real way as a goal for the new country and the rules of the game. When we talked about the distinctions between civil rights and civil liberties, the Bill of Rights was really mostly civil liberties, was about freedom, was not about equality. A reminder as well that the Bill of Rights was only limiting the federal government from infringing on these important liberties, and therefore the amount of liberties considerably from state to state, and therefore there certainly wasn't national equality in terms of protection of those important liberties. There was one exception. Right to a speedy trial is certainly a civil right. It is something, using the terminology we talked about in terms of positive rights. It is one in which the national government would need to take action. If you're going to have a right to a speedy trial, you need to have a court system, and you need to have that system put into motion by the government. Right, it's the one that we talked about that is unambiguously in the Bill of Rights. The Second Amendment, of course, depending on the interpretation, could be seen as a civil right. But the Sixth Amendment is clearly a civil right. And so that is one that is part of the U.S. Constitution. However, when you think about that, it can be and was undermined considerably when you talk about the number of individuals who were lynched because a mob would just be allowed to go into the jail cell of someone who was accused of a crime for an African American looking sideways at a white woman, or just being a woman in a particular way, would lead to lynchings. And lynchings happened throughout the country, not just in the South, but up until the 1960s. And so that is not a right to a speedy trial. A speedy trial, as we talked about with civil liberties, is meant to have certain protections for the rights of the accused, and lynching was deciding ahead of time that this individual was because of the color of their skin. And so when you take a look at that, you see that civil rights was not really an important issue to the framers. Another point is that slavery was allowed to exist. Slavery was considerably important to the U.S. Constitution, as we talked about. The Three-Fifths Compromise was one that said that slaves would, for every slaves, they would count as 3 for population purposes only. It had nothing to do with giving any liberties to those individuals. They were considered property. They had no individual freedoms. And that was allowed to stand, even though a number of the framers of the U.S. Constitution were morally opposed to slavery. Some were more cynically opposed to it, thinking that slavery would make poor whites lazy. But there was a whole range of opinions about slavery in the U.S. Constitution at the Constitutional Convention, and many of the framers spoke eloquently about how slavery was terrible and would be the downfall of this country. And yet, they allowed slavery to exist in order to move from the Articles of Confederation to the U.S. Constitution, instead of telling the slave states that if they wanted to join this new country or wanted to stay part of this country, they would have to get rid of slavery. Instead, slavery was allowed to exist. So clearly, that's another indication that civil rights, the idea of equality, was not important to the framers of the U.S. Constitution. And they were not allowed to vote. They got the right to vote in 1920 with the 19th Amendment to the U.S. Constitution. Property requirements were allowed because states were setting up the requirements for voting, and we see that states still have considerable amount of control over that, because there are some states, like North Carolina and many throughout the South, that have photo ID that you need to show in order to have the right to vote, whereas California and other states do not have that. And so that individual liberty that you have, it varies from state to state. And so, but going back to the U.S. Constitution, is that property requirements were often part of what you would have to demonstrate in order to vote. And so again, you'd have economic inequality to exist in terms of who could vote and who couldn't. And all of this is kind of summed up in the Dred Scott decision. Dred Scott versus Sanford of 1857 is pointing out sort of the viewpoint that and a review of the history of slavery in the U.S. Up until that point, leading to this really unfortunate decision, a 7-2 decision, in which the U.S. Supreme Court said slaves had for more than a century been regulated as beings of an inferior order and altogether unfit to associate with the white race, either in social or political relations, and so inferior that they had no man was bound to respect, and that the Negro might just be reduced to slavery for his benefit. And so it is clearly an indication that there was certainly a lot of inequality that was allowed to exist in the U.S. Constitution. And so moving to the next slide, when we talk about things seeming to change, we've talked about this already when we talk about the idea of the 14th Amendment particularly, but things seem to change when you have the Civil War amendments. The 13th Amendment in 1865 officially outlawed slavery in the U.S. Constitution. The 14th Amendment created national citizenship. It creates the Privileges and Immunity Clauses that says that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. It also includes the Due Process Clause. It says, nor shall any state deprive any person of life, liberty, or property without the due process of law. And finally, nor deny to any person within its jurisdiction the equal protection of the laws. So the Equal Protection Clause. Then we had talked about this when we talked about the idea of selective incorporation. The argument was made by some that once the 14th Amendment was ratified, then the Bill of Rights would automatically apply to the states, because in order for there to be privileges and immunities, the privileges and immunities that is given to anyone in the United States is certainly articulated in the Bill of Rights. The idea of the Due Process Clause, when you take a look at the 3rd, the 4th, the 5th, the 6th, the 7th, and 8th Amendments of the U.S. Constitution, that is the due process of law through which you have to life, liberty, or property can actually be limited or taken from someone. The Equal Protection Clause, in order to be equal protection under the laws, that should include the U.S. Constitution as amended. And so once the Bill of Rights was added to the U.S. Constitution, then that should apply to all of the states equally. But as we know, the U.S. Supreme Court is the one that gets to decide what the Constitution means, and they interpreted the 14th Amendment differently. And so it took a process of over 100 years for bits and pieces of the Bill of Rights to apply to the states. But on its passage, it seemed to really implement the 14th Amendment, really seemed to implement the idea of political equality in our system in a way that up until then we had never thought of. And the 15th Amendment in 1870, when it was ratified, then gave African American men the right to vote. And so in all of those, the 13th, 14th, and 15th Amendments, it seemed to have changed. So now the U.S. Constitution does have some real teeth in terms of talking about trying to achieve equality in our political system. But sadly, and it's not too much of a surprise, but the undermining of the Civil War amendments started relatively quickly. The 14th Amendment was undermined because the U.S. Supreme Court ruled that the Equal Protection Clause, was only from government discrimination. Individuals and other private institutions were allowed to discriminate, and then certainly took advantage of that and did discriminate for a long period of time, because the U.S. Supreme Court said that, yes, the 14th Amendment does exist. The Equal Protection Clause does suggest that, in fact, discrimination by government shouldn't be allowed, but that only applied to the government. And then in 1896 and onwards, with Plessy versus Ferguson, that we'll talk about a little bit later when we talk about, but in the court case of Plessy versus Ferguson, the idea that you could have separate but equal institutions suggested that the U.S. Supreme Court was actually okay with having even state-sponsored discrimination, because in the ruling of Brown versus Board of Education in 1954, which over Plessy versus Ferguson, it's just the ICEs and having separate institutions, in this case separate educational institutions, suggests that this is something that is inherently a mistake, is one in which equality is not achieved when you separate the races based on race. And so you can see them undermined by interpretations by particularly the U.S. Supreme Court in terms of how it interpreted and applied the 14th Amendment to different cases that it heard. The 15th Amendment was also undermined, giving African American men the right to vote. And as we saw, we know that it's effective because in the video that we saw in the chapter on democracy, we saw how few in the state of Mississippi in the 1960s were actually registered to vote, indication of the success of the ways in which the mind by a number of actions. And so those are due to the poll taxes, literacy tests, grandfather clauses, and white primaries. We're going to spend most of our time talking about the idea of the literacy test, but it is a combination of all of these things that made it so that we had so few people, for example, so few African Americans who could be registered to vote in Mississippi even as late as the 1960s. The poll tax is the idea that in order for someone to vote, they had to pay taxes in order to vote, and that was ruled unconstitutional in the 1960s. But up until then, poll taxes were allowed. That the idea of having photo ID is in fact a form of a poll tax, and that allowing that is a way in which you can have a poll tax because, as we talked about, some individuals have that photo ID already because they need a driver's license to live their lives, to go to work, etc. So they have that available. But many people don't have photo IDs. And in order to get that, they have to spend quite a bit of money because they have to prove their identification. They need to have their birth certificate. They need to have other documentation. They need to go to the courthouse in order to show all of that. And so that can be very complicated and very expensive. And so in some ways, if that's what you need in order to vote, it becomes like having a poll tax. The literacy tests are the ones that are perhaps the most insidious, and we want to spend a little bit of time on those in a few moments. But that was that you needed to take a test to prove competence to vote. And just like with photo ID, you can make an argument as to why it might be worthwhile to have something like that citizenship is so important, that voting is such an important part of a representative democracy. We want to make sure that people are thinking about these things and are doing it in a way that shows that they've reflected on their choices. But really, the literacy tests, as we're going to see, were ways in which to make sure that certain individuals, African Americans, would not have the right to vote, whereas others, whites, would be allowed to vote. The grandfather clause was put into place, as we're going to see, particularly with the literacy test, but also with the poll tax, is to say that certain types of restrictions on voting could be something that would limit both African Americans and poor whites. And so one way to get around that is to have the literacy test, to have the poll taxes, but then to say that if you had a grandfather who had the right to vote, you could avoid paying the poll tax, you could avoid taking the literacy test. And of course, when you did that in the 1960s, the people whose grandfathers had that right were whites, whereas African Americans, their grandfathers were slaves and therefore didn't have that right. Getting around the way in which the poll tax or the literacy test would catch poor whites in addition with African. The other thing that were used, and white primaries were the idea that political parties would choose their nominees who would then run in the general election. We're going to talk about, of course, when we talk about campaigns and elections, and we talk about political parties. But the way our system works is it's a two-stage process. You first need to get the nomination of your party, and once you have that nomination, then you go to the general election. And so what happened is that political parties are not listed in the U.S. Constitution, and they were seen by government officials to be private institutions. Even though the impact of political parties, as we're going to see, is immense on the way in which our government works, political parties are not officially part of the government. And therefore, even though states were not allowed to discriminate based on race, the national government wasn't allowed to do that. Private institutions could. And so political parties would. And so they would say that in order to run in a primary, you need to be white. And what that meant was that even if an African American or African Americans were allowed to get the right to vote, by the time they had a choice, because they couldn't participate in the primaries either, to run for a primary you had to be white, but also to vote in the primaries you had to be white. But they couldn't be excluded necessarily from the general election once they actually registered to vote. But at that point, the only candidates available would be whites. And so it would limit the choices that were available to African Americans. And so in that sense, you could see a whole collection of ways in which there were decisions that were made by government officials, and not simply in the South, it's most clearly in the South, of ways of intimidating and to discriminate against African Americans. And so what we want to do is to end this section, this smaller lecture, with a look at the literacy tests. And so what I'm asking you to do is to take a look at the 1965 Alabama literacy test at the outset. There's a link there on the slide. It's worth taking a look at. What I suggest in parentheses is just without taking a look at the answers are provided on the last page of the PDF, but without taking a look at the answers, think about whether or not you would be able to take that test and pass it. And to think about the fact in a college level course about American politics, and that if you find those questions hard, obviously other people who aren't nearly as educated would find a difficult time passing these tests. In addition to the whole done is that there was intimidation on every step of the way of deciding that you were going to ask even to be registered or to go and register to vote, and then you would have to sit down and take this test in order to get the right to vote. And the test would then be administered by government officials. They would have really strict time limits. They would be around while you're taking the test, and certainly making it a very difficult test. And then if you take a look at some of the questions that are on there, you can see pretty early on, and I ask you to take a look at page 3, questions 27 to 39, but you can take a look at any page to see that there really is a larger goal in mind that isn't really about testing citizen competence or literacy. Instead, it was just finding ways of asking tough questions that people won't be able to answer in order to make sure that they won't be able to vote. But I also like the Alabama one because there also seem to be other messages that are being sent on the test. So certainly they're very difficult. But in addition, is some of the questions, like question 27, 34, and 37, seem to be put in talk about the larger political context in which this is happening. And so there's some intimidation. So when you take a look at question 27, it's pointing each state has a right to form a militia. The answer is a militia. It's pointing out the violence. The militia that were set up in southern states were often the forms that would intimidate the people who were even asking the right to vote. If you take a look at question 34, it's talking about involuntary servitude is permitted on conviction of a crime. It's talking about the idea that people are going to be sent to jail. Why are you asking this question? It's just to point out that if you ask for certain things and are not happy with their answer, then you might actually be sent to jail. And if you take a look at question 37, it says, which of the following is a right guaranteed by the Bill of Rights of the United States Constitution? Education, voting, or trial by jury. And the first three are not actually rights that are guaranteed by the Bill of Rights. Public housing, education, voting. Trial by jury is the only one that is allowed there. And so it's pointing out that you don't have individual freedom to vote. You don't have, as many were asking for, is education and public housing to be expanded. And so in many ways, there are other messages being sent by these literacy tests, role of making sure that people they didn't want to actually pass the test would be able to get the right to vote. There's also the question of why would anyone care about the question of question 30, which of the original 13 states, which one had the largest representation? It's Virginia. It's clearly a love of the South, but why people would need to know that information in order to have the right to vote, even if they were living in Virginia. And this is the Alabama literacy test. We're not talking about Virginia. But clearly, this test is sending a message more than simply its role of trying to make sure that certain people would get the right to vote. It's not the only example of them. There's some other ones. Louisiana's is one that's often used by people. There's a link at the bottom of the slide if you want to take a look at that one to show some of the absurd questions that are there. Certainly if you have to do it within 10 minutes, which is the time limit for the Louisiana one, and again, it's 1964. The one that's almost paradigmatic is the question of how many bubbles are there in a bar of soap? That's the one that's often used because, of course, there is no answer to it. And so it's pointing out that anyone can ask a hard question. Anyone can come up with a difficult exam. And it's also a reminder of why, if you have tests like this, you would need something like the grandfather clauses because they were so tough that no one was going to pass these, in which you would make sure that certain people wouldn't have to pass the test. It's to say, well, if your grandfather had the right to vote, you automatically have the right to vote. But that meant that African Americans, whose grandfathers in the South were slaves, didn't have that right to vote. And so you could target this, still have these tough exams, but then targetedly discriminate against African Americans and didn't allow them to vote.